Okay, we are ready.
Welcome and thank you for joining Seyfarth's webinar, Washington Labor and Employment Legislative Update, What Employers Need to Know. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your window. We will do our best to get to everyone's questions. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendee verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Helen McFarland. Helen, you may begin.
Thank you. Happy St. Patrick's Day and top of the morning to all of you. My name is Helen McFarland. I'm a partner in the Labor and Employment Group of Seyfarth's Seattle office. And I'm very pleased to welcome you to our discussion about the newest employment laws in Washington. The Washington legislature was very busy this session, and many of these laws were signed by Governor Inslee within the last week. Several more have recently been presented to him and are awaiting either his signature or veto. So we're going to be providing an overview of the key points from each law and other things we hope you as employers in Washington will find useful in the coming year. But first, we'll start with introductions. Next slide. Again, my name is Helen McFarland. I represent employers of all sizes in Washington, Oregon, and California. I really handle the whole gamut of employment issues, both in counseling, on agreements, policies, or accommodation requests, and in employment litigation before agencies and state and local courts. Patrick.
Good morning, everybody. My name is Patrick Joyce. I am a new partner in the Seattle office. I moved from Chicago more towards the beginning of last year in 2021. My typical focus is on OSHA and environmental areas of law, so employee health and safety. Of course, during the COVID pandemic, I've been dealing a lot with working with employers, putting mitigation measures in place, taking them away, kind of as we go back and forth in these various waves and surges. So I'm very happy to be in the Seattle office and very happy to meet all of you today.
Good morning, everyone. My name is Eddie Alvarez. I am senior counsel here in the Seattle office. I'm barred in Washington and California, and my practice focuses kind of the gamut of employment litigation. I do have a focus on wage and hour litigation in Washington and California, but kind of, again, my practice goes through the gamut, defending employers mostly. Happy to be with everyone this morning.
Okay. So next slide. So our agenda for today, we are going to start with a brief summary of some of the basic laws that took effect on January 1st, but they were actually passed in the 2021 legislative session. As a quick primer, once a bill is approved by both the House and the Senate, it is signed by both leaders and presented to the governor for signature. If the bill is presented to the governor during the legislative session, he has 5 days to act. If the bill is transmitted within 5 days of the close of the legislative session, the governor has 20 days to act, or the bill automatically becomes law. So the Washington session closed on March 10th of this year, and we don't have a final determination on some of these bills. However, we know that no other bills can be presented to the governor at this time. So after a brief summary of the new laws in effect as of January 1st, 2022, we will start with all the laws that have been already signed and enacted. We will then move on to the bills that have been presented to Governor Inslee and that are awaiting his signature or veto. Next, we'll address the status of the COVID requirements for employers as we hopefully continue to emerge from the pandemic. And then finally, we'll discuss a new important ordinance that applies to Seattle independent contractors. If we have time, we have some highlights on other sort of less important legislation, but we may not get to those. Again, as Kim mentioned, please feel free to submit questions in the Q&A, and we will try to address those either at the end of the webinar or perhaps in some other way. Okay, so moving on to laws in effect as of January 1st. There have been increased minimum wages the minimum wage here in Washington increased to $14.49 per hour, which has a ripple effect on several other wage issues, as you'll see in some of these other next slides. In Seattle, the minimum wage is much higher, and it varies depending on the size of the employer, whether you're going to be providing health insurance and or if tips are part of the compensation. So if you're a large employer of more than 500 employees, you're going to have to pay $17.27 per hour in Seattle. And then depending on if you're paying any money toward medical benefits or tips, it's either $15.75 or again $17.27. Senate Bill 5172. Oh, so the next is agricultural minimum wage, and as of January 1st, agricultural workers are beginning to be phased out of their exempt status. Many of you may know that in November of 2020, the Washington Supreme Court issued the Martinez-Cuevas decision that held that the overtime exemption as applied to just dairy workers was unconstitutional for several reasons. The decision left a lot of unanswered questions, including whether the reasoning would be applied more broadly to other agricultural workers and whether there was any retroactive effect. So Senate Bill 5172 answered many of those questions. It was signed in May of last year, and it offers protections to employers who previously relied upon the overtime exemption, but it sets up a gradual phase out over the next few years. So you'll see for this year, January 1st of 2022, any employee who's working more than 55 hours in the week is entitled to overtime, and then it decreases to 47 in 2023, and then it kind of goes to the regular 40 hours a week as standard in Washington by January 1st of 2024. Okay, next slide. So speaking of overtime exemptions, they are based on the minimum wage. So the salary threshold for overtime exempt employees in Washington has increased as of this year to $52,743.60 a year. It's 1.75 times the minimum wage. Similarly, the salary threshold for valid non-competition provisions increased in January. So in order to now enforce a non-compete provision, in addition to the other requirements under the law, an employee must earn at least $107,301.04 per year, and an independent contractor must earn at least $268,252.59 a year. Next slide. As many of you know, the fairly controversial Washington CARES Act was originally scheduled to go into effect on January 1st of this year. Everyone was scrambling in the fall to try to obtain long-term care insurance and obtain exemptions. But the 0.58% payroll tax on employees in Washington with no caps on deductions was set to begin January 1st. At the end of 2021, there was litigation filed in the Western District of Washington to address several perceived problems. And on January 27th of this year, Governor Inslee signed two bills, House Bill 1732 and House Bill 1733, to address some of these concerns and to make some key improvements to the Washington CARES Fund. So the changes include giving the benefit to workers near retirement, and that had not been available under the existing or prior law. It addresses the big concern of the employers who work, the employees who live out of state and work in Washington, and several other categories who are going to have to pay into the fund but not be able to recover any of the benefits. And it essentially delayed the whole implementation until July of 2023. There was, I think, quite a debate in December about whether to actually start to begin deducting premiums under this act, and sort of conflicting information from the legislature and the governor. But these two laws made clear that for any employer who did begin those deductions, you need to refund all of those premiums, and the premiums need to be refunded within 120 days of the law. So if you have not made those refunds of deductions that were withheld, you should be cognizant of the time and make sure you do that within the next month or so. Next slide.
So we also have the new Washington Wage Recovery Act. The new act allows certain employees to place a lien on their employer's property to secure unpaid wages and other compensation. So under this new law, employee is broadly defined, and it includes any individual currently or formerly employed by an employer, but it does not include highly compensated employees where, compensation was at or above $130,000. So this, the types of property that are subject to wage liens includes any real property in the state that's owned by an employer, goods and tangible chattel paper in the state, and accounts and payment intangibles. Next slide. So there are certain requirements for employees for recording a wage lien. For example, the wage lien must be recorded within 2 years from the date the wages were first due. The wage lien must be filed in the county where the property is located, and there's a filing fee among some of the requirements. And employees must then file an action for the underlying wage claim within 8 months of the date the wage lien was recorded. And employers do have defenses, so those who believe that the claim of the lien to be frivolous, excessive, or made without reasonable cause may file a motion in court. And the motion would be for an order directing the employee to appear and show cause as to why the relief should be granted. And so the practical impact of this law is, before the law is currently Washington employees had to wait until after the resolution of a lawsuit or a government investigation to receive payment of unpaid wages. But under this new law, employees can now hold a security interest in the employer's property while they wait for a resolution.
All right, thanks, Eddie. So now we're going to move on to some of the newer laws from this 2022 session that have been signed and enacted, and now are session laws that are effective. So I'm going to start off with the Substitute Senate Bill 5890, and this has to do with expanding a presumption for workers' compensation coverage for individuals who work at radiological hazardous waste facilities. And you might be asking, well, why does this apply to me? Why do I care? Well, first I'm going to get into, this was signed by the governor on March 11th. And because it had an emergency clause in it, it was effective immediately. So it was effective March 11th in 2022. What it does on its face is expands coverage. It redefines the folks that are covered by this presumption for working at radiological waste facilities, takes out the reference to the Hanford nuclear site, and adds in any employee that's exposed or any employee that works at a high hazard nuclear waste facility. And the intent of the law was to cover inspectors and contractors and folks who went on site to Hanford and had to deal with this nuclear waste, which I'm sure you all have heard over the years is an ongoing project, and provide them with a presumption of workers' compensation coverage for certain illnesses, cancers, and things that arise out of dealing with nuclear waste. What kind of perhaps, and we'll see when some guidance and other information starts coming out on this, perhaps the unintended consequence of this is, as part of removing the reference to Hanford and making it cover all employees who work at, I'm not going to read it here, but any structure basically that deals with this waste, and then also expanding the definition of what a waste is. There are some medical, laboratory, commercial operations that utilize some of these nuclear materials, especially radium-226. Radium-226, if you think back to the 1920s and 1930s with watch faces that would glow in the dark, that uses radium-226. Radium-226 is currently used to make radon gas and other cancer, fighting cancer materials. So what could happen is in the production of those byproducts, this radon gas, or using it for luminous painting, the person who's handling the waste product could become covered by this bill. We still have to see how it's going to actually play out, but I think that was an unintended consequence of the bill that was really aimed at protecting these inspectors and third-party contractors that came on site to Hanford. It also removes a presumption of communicable respiratory diseases, specifically aimed at COVID-19 at the Hanford site, but that's not quite as important as maybe the unintended consequence of the radioactive materials. All right, moving on.
So another enacted law here is one that protects the confidentiality of employees who use employee assistance programs. And the governor signed this on March 4th, and it has an effective date of June 9th, 2022. So a bit of background here. Certain employers provide, their employees with employee assistance programs through benefits packages. And the programs are offered as part of a benefits plan and provide support for work and life concerns such as depression, stress, addiction, and some, I think, even provide help for like financial and legal issues. And this bill provides the same confidentiality protections for private EAPs as those outlined in the Washington State Employee Assistance Program, which is available to state employees. And the new bill makes it unlawful for an employer to obtain individually identifiable information regarding an employee's participation in an EAP. And also, an employee's participation or non-participation in an EAP must not be a factor in a decision affecting an employee's job security, promotional opportunities, corrective or disciplinary action, or other employment rights. And here, the practical takeaway is it just helps provide assurance to employees that they can seek through their employer-provided EAPs protection and seek assistance through them, knowing that any information disclosed will be kept confidential. Next slide. This is shared responsibilities for the LTSS and PFML programs, and the governor signed on March 11th with also an effective date of June 9th. Here, information on individuals or employers obtained through the collection of premiums for the long-term services and supports program must be kept private and confidential in the same manner as in the paid family medical leave program. So under PFML, the Employment Security Department must keep information regarding individuals and employers private and confidential. However, the ESD may disclose this information in certain instances to a third party acting on behalf of the employer or the employee, or to the legislature with signed releases. But the new law here is actually intended to allow the ESD to administer the PFML and LTSS programs side by side, and it allows confidential information or records in the PFML program to be disclosed to state agencies for administering the ESD's responsibilities under the LTSS trust program. Next slide. So this is the elimination of sub-prevailing wage certificates for individuals with disabilities, SB 5763, signed by the governor on March 11th and also has an effective date of June 9th. So, we start with the law here that currently Washington requires prevailing wages to be paid to laborers, workers, and mechanics employed upon all public works and under all public building service maintenance contracts. But the director of the Department of L&I can provide for the employment of individuals with disabilities at wages lower than the applicable prevailing wage rate through the issuance of special certificates that are valid for 1 year. And while the Department of L&I has issued those certificates, the new law repeals the current statute requiring the issuance of these certificates. So while no sub-prevailing wage certificates are currently in use, supporters seek to eliminate opportunities for people with disabilities to be paid at lower wages. Next slide. So employers to reimburse employee fees when paycheck is dishonored by non-acceptance or non-payment, SHB 1794, and this was signed by the governor on March 11th with an effective date of June 9th, 2022. So we start with the obvious, right? That it's unlawful for an employer to deprive an employee of his or her minimum wages. And one example of a failure to pay wages owed is if a paycheck is denied for non-sufficient funds. Under the new law, employers that pay employees with an instrument that's later returned for non-sufficient funds must reimburse the employee for fees charged by the employee's financial institution unless the employer can show that it was returned due to error. So there was kind of a lot of back and forth while this new law was going up through the legislature. Supporters, they claimed that it was a simple bill, right, because the vast majority of employers pay employees correctly, but that the Department of L&I gets around 220 wage complaints each year regarding a failure to get paid specifically due to a bounced check. People who opposed this as it was coming up said that, in some cases, small business owners were not at fault for the bounced check, and if the bank was at fault but they didn't disclose that, or if the fault lied within a third party, under the bill, the employer would still be held responsible. So that was a little bit of the back and forth that took place with this bill, but it was ultimately signed by the governor on March 11th. And so now we get to bills that are currently on the governor's desk, but that Governor Inslee has not acted upon. This is probably one of the most kind of important that would have the most effect on, employers here in the state, and it's SHB 1795. And this is an act related to prohibiting non-disclosure and non-disparagement provisions from employers regarding illegal acts of discrimination, harassment, retaliation, wage and hour violations, and sexual assault. So under the current law, it prohibits employers from requiring employees to sign a non-disclosure agreement preventing them from disclosing sexual harassment or sexual assault occurring in the workplace and at other work-related events. But it currently does not apply to confidential settlement agreements. This bill would repeal and replace the current law, and it would prohibit non-disclosure and non-disparagement provisions in agreements not to disclose conduct or even settlement involving conduct regarding, and it just expands the scope of what would be prohibited. For example, discrimination, harassment, retaliation, wage and hour violations, and sexual assault taking place in the workplace or at work-related events or between employees. If we go to the next slide, please. Prohibited provisions include those contained in employment agreements, independent contractor agreements, agreements to pay compensation in exchange for the release of a legal claim, or any other agreement between an employer and an employee. And an employee, again, is defined broadly, and it means current, former, and prospective employees or independent contractors. So the law would apply retroactively to invalidate provisions and agreements in effect before the law came into effect that were agreed upon at the outset of the employment or during the course of employment. But here, the retroactivity clause would not apply to non-disclosure or non-disparagement provisions in an agreement to settle a legal claim. Under the penalty here is employers are liable for civil cause of action for actual or statutory damages of $10,000, whichever is more, and reasonable attorney fees and costs. And if you could go to the next slide.
So I think this is me, and I will jump in, but I just kind of want to emphasize how important 1795 is. I mean, so many employers, in separation agreements or in any kind of settlement agreement that they're engaging in with former employees, almost everybody wants to have a non-disparagement provision and some kind of like a confidentiality provision. And this law effectively eliminates those, for any claim that might even smell like a wage and hour dispute or any kind of discrimination claim. And it's very broad. There's no carve-outs, you know, it's kind of alarming because I don't know, I mean, it doesn't even give you an option for the employee to request it and to have that be allowed. And, you know, and then it sets these penalties for just even having a non-disparagement agreement or a provision in your agreement, and sets a civil cause of action. So this is something that almost everybody will probably have to be aware of if it is signed. There has been opposition to it, and, you know, I know, I guess we'll see what happens with Governor Inslee. It's sort of the natural, it's come out of the California law that's similar on this, but it's broad, and so people will probably have to revisit their separation agreements and, you know, settlement agreements and expectations on that front. Okay, so sorry to step on Eddie's slide there, but I just wanted to emphasize the importance of that bill. Okay, so the next one is another sort of cleanup, but also important bill that relates to the Washington Paid Family and Medical Leave Act. As you all likely know, this program went into effect in 2020, and so this kind of does a little bit of cleanup of some of the specific things, such as allowing predetermination of eligibility and benefits for some employees who may be applying. It also very clearly defines something called a postnatal period, which is after a woman has a baby. The first 6 weeks after that baby is born will be defined as a postnatal period. And now during that postnatal period, this law, if it is signed, will say that an employee must take family leave. I'm sorry, it must be medical leave instead of family leave for purposes of their time off, unless the employee wants to use family leave. So I think it sort of puts in this automatic disability, which is fairly standard for any woman who has a baby during the 6 weeks following the birth. So that's one of the key terms. Another sort of important term is that it allows employees to take leave under the PFML for a death in their family. And I think that's kind of a new, interesting way to codify a bereavement leave. You know, many employers have a bereavement leave, but this now is allowing an employee who would qualify under the Paid Family and Medical Leave Act, which, as you all probably know, is just working for 820 hours in the last year for any number of employers. But they can now use their paid family leave for the death of a family member who would have otherwise qualified them or entitled them to leave. And it looks like it's for 7 days. So, you know, that's a pretty substantial additional leave that employees probably didn't have. Has a couple of other cleanup issues, but this is probably one that will be signed at some point. It's you know, going to just hopefully speed up the processing a little bit, and help the ESD go through some of these multiple claims that they have sitting on their desk and avoid delay.
So I'll be talking about SSB 5761, and this is concerning employer requirements for providing wage and salary information to applicants for employment. So under the current law, if an employer has 15 or more employees, upon request of an applicant for employment, after the employer has offered the applicant that position, or if a current employee is offered an internal position or a promotion, the employer must provide the minimum wage or range scale for that position. And this bill would remove the employer requirement to provide the salary information after an initial job offer upon request of the applicant. Instead, beginning January 1, 2023, the bill would require employers to disclose in each posting for each job opening the wage scale or salary range and a general description of the benefits and other compensation to be offered to the hired applicant. So posting is actually defined very broadly, and it includes like any solicitation intended to recruit job applicants for a specific available position It includes recruitment done directly by the employer or indirectly through a third party. And it includes any postings done electronically or with printed or printed in hard copy that includes qualifications for desired applicants. And again, there's been opposition to the bill and support, right? Supporters of the bill claim that it promotes pay transparency and that Washington would join 14 other states that have passed similar salary disclosure laws. Supporters claim, it'll benefit people of color, minorities who may, be offered less money, is the argument. Those who oppose the bill claim that it may require information to be public that is proprietary or confidential and unique to employers. They claim that it also raises employee privacy issues, for example, particularly for those who are in the process of leaving a job and their old job salary is disclosed. Other opposition kind of arguments is just the practicality of updating postings, having to go through all the postings available or that may be available and including that information. And that, again, that includes when companies work with recruiters and third parties and having to update all of those. So just the practicality of going through that is also one of the arguments. If we go to the next slide, please. So this is concerning the rights and obligations of transportation network companies and transportation network company drivers. So TNCs, it's a typical rideshare companies, and in Seattle, we have other delivery-based companies that qualify under this TNC definition. So current regulations of TNCs generally only address liability insurance requirements. For example, TNC drivers must carry certain insurance, coverage amounts deferred depending on whether the driver is transporting a passenger or not. And SHB 2076 includes various provisions, including, regarding minimum driver compensation, notices, paid sick time, industrial insurance. So I could provide a few examples here. Like, for example, for minimum compensation, beginning in December 31, 2022, a TNC must ensure that a driver's total compensation is not less than, for example, in big cities and counties, so Seattle City or King County, which they meet the population kind of requirements of the Act, 59 cents per minute and $1.38 per passenger platform mile, or a minimum of $5.17 per dispatch trip. So that's 5.17. For all other trips, minimum of $3 per dispatch trip. So the bill would also include like posting requirements and notice requirements that, notices to drivers about their rights, including the right to a guaranteed per minute, per mile, per trip rate, and the right to be protected from retaliation. It would provide receipts to each rider containing certain information. It would include paid sick time. So beginning January 1, 2023, the TNC must provide drivers paid sick time of 1 hour for every 40 hours of passenger platform time worked. And it would have, provisions on how to accrue that sick time. And the bill would include other provisions, such as a fund for a driver resource center to, among other things, support drivers in resolving disputes with the TNC. So it's a super broad bill. It's pretty detailed. Again, I think this kind of falls as we're seeing a trend for these companies and legislatures wanting to provide protection for these drivers. And we'll see what the governor does with this. It's pretty detailed, as I mentioned, so we'll have to wait and see.
All right, so I'm going to talk about SHB 1902, which again has not been signed. It's been delivered to the governor. What this bill does is it addresses a pretty narrow issue that has arisen in the course of workers' compensation claims and employees who may receive services related to their original claim after the claim has been closed. And there's a reopening provision where an employee is allowed to seek reopening within 60 days of a service being provided to get reimbursement for that service. And there were a couple of narrow instances where an employee would try to get the reopening within the required period of time, but then a provider would not submit the provider portion of the reopening paperwork, the form, to L&I or to the self-insured, if it's an employer that's self-insured, within the required 60-day window. L&I, then said that they weren't able to reopen the workers' comp claim. So what this bill does is, in a case where a provider does not provide the required information to L&I or to the self-insurer within the 60-day window, the employee can ask L&I to extend the reopening period to 120 days, services provided within 120 days from the reopening, if the employee can demonstrate that they completed their portion of the application within 30 days of the services that they received. So there's a couple of hoops to step through here. It's really aimed at dealing with providers who may not, in the pandemic here, a lot of folks have been down on staff. They've been slow to do paperwork. They're focusing on patient care, that type of thing. So it's really designed to address those situations where someone may not submit paperwork within the required time frame. All right, so this is kind of my jam here, where I've been working with employers over the last 2+ years, really since actually December of 2019, when folks started calling saying, "Hey, I've heard about this new thing called COVID-19. What do I do?" It feels as if we're on a downward trend here, and I know we've all seen this before. Last summer, kind of at the end of the Delta wave, and then Omicron came up. We feel like we're in a pretty good spot now. I'm sure you're hearing across the country, mask mandates are going away, actually have gone away. Any other sort of mitigation requirements have been rescinded. Vaccination proof requirements are starting to go away. And I'm going to focus here on what Washington State has done, but across the country, as I'm sure you're all aware, things are starting to, have reopened. As you all know, Washington's statewide mask mandate, and then all of the counties who had kind of triggered theirs based upon the statewide mask mandate, expired at 11:59 p.m. last week. Masks are no longer required for general indoors activities. But of course, there's other laws that are still in place. The federal public transit and airplanes, you have to wear masks still. That was just extended until April 18th. The Biden administration had said maybe they're going to extend it again, but with reduced requirements. Governor Inslee and Department of Health and L&I have issued updated guidance and directives having to do with the removal of the mask mandates, but masks are still required in healthcare, correctional facilities, congregate care, a couple of other situations where employees may be expected to be in contact with people who have or may have COVID-19. So just keep in mind that you may be in a situation where you're, one of the things we've seen is, say you have a pharmacy within a broader retail context. Currently, what Washington is saying, and we know that there are folks working on getting this changed, is that those pharmacy folks still have to mask up. Hopefully that will be clarified and maybe even changed in the near future here. As it relates to vaccinations, again, the state employees and healthcare providers within the state of Washington, schools, and a couple other areas still have required vaccination for their employees. King County ended its proof of vaccination requirement to allow individuals to go into restaurants, gyms, bars, etc. On March 1st. Although for those of you in King County who either work or live in King County, know that some restaurants, some gyms are still requiring proof of vaccination, but that's their choice. The employer has the ability to, they could require masks, they could require vaccinations if they wanted to. So just be aware as you're out and about as to what the individual requirements of a business may be. Again, we've seen this before. Things have often changed rapidly during this pandemic. I've turned into a nerd in terms of epidemiology over the last couple of years, and there is, right now it's looking like there is an uptick in the BA2 subvariant. I'm sure you guys have heard of that, which is a subvariant of Omicron. It is starting to tick up. The public health folks don't know if it's going to turn into a new surge, if it's just going to be nothing. So that's something to keep an eye on, that provisions may be coming back into play or may not. We just don't know at this point in time. The BA2 is what's in China and in Western Europe right now, and they've seen some pretty big surges. So we're hoping that because Omicron was so prevalent in the US, that BA2 will not become prevalent. For those of you in the grocery industry, I'm sure you know about the hazard pay provisions that were put in place by the city of Seattle and by Bellingham. There were several other ones in the state that have since been rescinded, but I'm just going to focus on city of Seattle and Bellingham. These were both effective early 2021. Both required hazard pay to grocery workers, and it's spelled out specifically within the ordinances as to the size of the facility and the ratio of grocery to dry goods that must be sold to qualify. The Seattle one does not apply, generally speaking. There are a couple of exceptions to salaried workers. Both of these ordinances have anti-retaliation provisions, and they say that facilities such as convenience stores and food marts, whatever that means, are not covered by these requirements. We've been tracking these very closely. At the end of the Delta surge, kind of in the summer, late summer, early fall timeframe, the city of Seattle had introduced legislation to sunset the ordinance. Then Delta happened, then Omicron happened, and they withdrew that legislation to sunset it. Right now, we work with a couple of groups that are working to get it back on the sunset timeframe, but we're just not there quite yet, at least as of the last I heard earlier this week. Bellingham has told us, we've spoken with them, that they are following the city of Seattle's lead. So if the city of Seattle sunsets theirs, there's a strong possibility that Bellingham will sunset theirs as well. There are others out there too. California was really big on this, but I think almost all the ones in California are gone now too. So throughout the pandemic, there have been a number of protections put in place for high-risk workers, folks who are at, elderly, might have a medical disability, might have some other thing that puts them at specific high risk for working in the workplace. Governor Inslee originally had a proclamation that he issued at the very beginning of the pandemic that protected these high-risk workers. He amended it several times. The final version was rescinded in mid-2021 and rolled into kind of a broader COVID-19 safe worker protection proclamation. Basically what it does, and it's still currently in place, is it protects folks who take time off to recover from vaccination, recover from COVID, deal with deal with family members that have COVID or things like that. Protects those folks from retaliation, against retaliation by the employer for taking those actions. So just keep in mind that that's still in place. And the recommendation within the current COVID-19 safe workers is if these folks do come back, that they should, it's not required, but should wear a face covering when they come back from taking care of a family member, that type of thing. So a lot of you probably know about about HELSA, as we've been calling it, Health Emergency Labor Standards Act. This was effective early 2021. Again, it's another kind of anti-retaliation provision, a law that's aimed at frontline workers. And frontline workers is defined very broadly. I've got a list here. It's a lot of folks, first responders, food manufacturing, processing, all the way down through transit drivers, restaurant workers, that type of thing. Protects them against any infectious and contagious disease. It is not specifically tied to COVID. So what L&I will do is they will indicate in the future, if hopefully we don't have anything like this happen again, but if we do, they'll say, okay, this new disease is covered by HELSA, and what it does is it protects, first of all, it provides a presumption of workers' compensation coverage if the disease is contracted as part of the employment for this whole list of frontline workers. It requires employers that have more than 50 employees to notify L&I and Washington OSHA if there is an outbreak, which is, it's got some complex provisions, 10 or more employees within a 14-day period. And then there's kind of like a rolling continued notification period. And then again, as I said, there's a notice requirement too. So if someone is exposed in the workplace, you have to provide notice to other employees and to the union, if it's a union facility, and to subcontractors who may have had their employees in the workplace when this exposure occurred. As I mentioned already, that there's some anti-retaliation and protections for high-risk employees contained within this bill as well. All right.
And so I would say, hopefully Patrick and his nerdy digging into the next variant will prove to be wrong. But I will say that you probably are all familiar with the fact that there is a new also wave of litigation kind of coming out of these COVID restrictions and some of the things that employers have decided to do to try to protect their employees. I think there's been a lot of publications lately talking about the thousands and thousands of charges that have been filed with administrative agencies for accommodation requests related to COVID. And also, I think, as you're also probably aware of, religious requests. And so I think in the next year or two, we're probably going to be seeing a whole host of litigation, a whole host of cases here in Washington as well, really digging into the details of what, is a disability and what is a proper accommodation request. People get very tied up on the fact that they were able to work from home. A lot of them were. And so they say that it's not an essential function that they come into the office or that they be in person. And, and it's just, I think we're going to see a lot of that in the coming year, maybe 2 years.
Hey, Helen, can I just jump in real fast here before you move on to this Seattle independent contractor? Sure. I'm going to read the CLE code for everybody. So for those of you who are, kind of listening and doing other things, here is the CLE code. It is SS, so that's Seyfarth Shaw 3324. Again, SS as in Seyfarth Shaw 3324.
All right. Thanks, Patrick. Okay, so next slide, please. So for those of you who have employees in Seattle, we have a new independent contractor protections ordinance. It's very important because, it's pretty broad. It's SMC 1434. It goes into effect September 1st of 2022. And it applies to any independent contractor working within the geographic limits of the city. Pretty broadly defined, but it's supposed to address, one person who's working as an independent contractor, regardless of corporate form. So a company that might be an LLC, that's really just a sole person who's working, that's going to be someone who's covered. It applies to, any hiring entity, whether it's a nonprofit, a small corporation, corporations located out of state. I mean, it's very broadly defined. And it also applies, if the work is to be performed in whole or in part in Seattle, if the hiring entity knows or has reason to know that the work might be performed in whole or in part or in Seattle, and if they hire the independent contractor for services in the course of their business or commercial activity. It covers anybody who's going to earn at least $600, which, probably encompasses most independent contractors. and it actually only provides a couple of exemptions right now. One of them is lawyers, and the other is an independent contractor where the hiring entity is limited to a property rental agreement. So, and the example that the city has given is a hairstylist renting a booth at a salon. There may be others that will be defined, but at this point, that's all we have. So this is, I think, a counterpart to the Seattle wage theft ordinance, which requires a lot of different disclosures to be provided to employees working within the city of Seattle. And this is now, hopefully, I mean, I think what Seattle is intending is to have similar disclosure requirements for anybody who's working at all in any capacity within the city limits. So next slide, please. So this independent contractors protection ordinance sets forth a lot of disclosure requirements. First, there has to be a written disclosure prior to beginning any work and prior to any change. Now, this is, again, similar to the wage theft ordinance, in which you're required to have disclosures, but you're also supposed to have a disclosure at the time of payment. The only exception to that is for gig workers, such as Uber and Lyft. They don't have to do certain disclosures, but other than those, that one carve out, the disclosures are required for everyone else. They have several different things that you need to disclose, including the current date, the name of the contractor, the hiring entity, the contact information, the description of the work, the location of the work, and then we get into all of the terms about the pay, which is a little bit different than, you know, your typical independent contractor agreement, where sometimes you will just have a lump sum. But you have to identify rates of pay, any applicable multipliers, any variation in the pay, incentive pay. You have to identify the pay basis, whether there are any tips, and whether there are any expenses that can be incurred within the course of the assignment. You have to identify deductions, fees, or other charges, the payment schedule, and there's kind of an overarching any other information that's material or necessary. So it's pretty broad. The City of Seattle is going to be distributing sometime between now and September 1st a form that it expects any hiring entity to use as a hiring disclosure. And then, you know, I guess another most importantly is that you have to pay in accordance with these disclosures. So it sets up, you know, very clear contractual, like in addition to your other kind of breach of contract, it sets forth other protections to independent contractors. You have to provide a notice of rights. Again, that's going to be, I think, a form that will be distributed at some point in time before September. You're going to have to then make sure you pay clearly in accordance with all of the terms that you have in your disclosures, but then there's also a provision that it has to be paid within 30 days of completion. So I've already had some questions about, you know, what happens if it's a commission basis, you know, what if it's not 30 days of completion of the work because you're actually being paid on commission and you're waiting to get some of the money. I mean, I guess we'll see what happens with some of that, but that's something to be decided and worked out, I think, between now and September. The protections ordinance, again, sets up disclosure of certain maintenance requirements for records for 3 years, and it provides anti-retaliation provisions. So, but I think the scariest part of this ordinance is that there are so many rebuttable presumptions in favor of the independent contractors. So if you make any mistake, and there, you know, as you can see, there's several specific things that you need to disclose, provide terms in writing, and if there's any error or if you fail to comply with the strict requirements, there's going to be a presumption against you and in favor of the independent contractor that needs to be overcome with clear and convincing evidence. And that's, you know, it's not just about, it's kind of weaved all the way through this ordinance. It's just everything's going to be favoring independent contractors. If there's an adverse action within 90 days of the exercise of rights, so that could be, you know, somebody saying, what are the terms? Can you provide me these terms again? And then you decide to terminate the work within 90 days. There's going to be a rebuttable presumption of retaliation. So it's scary, I think, particularly because it's OLS that is going to be overseeing the enforcement, and they have the authority to investigate, to issue penalties, and also to and also there's a private right of action for any contractor. So for those of you who have had experience with Seattle, I think everybody knows that the OLS is very aggressive. They like to investigate very thoroughly whenever they have the authority to do so. Those investigations are very very time intensive. They can take, you know, years, and they don't just limit their investigation to the specific issue. I mean, I think OLS has been known to find one complaint and then dig into other things. So I think it's something that everybody needs to be aware of. And if you have any employee who might even live in Seattle and potentially could be working from home, it's something you should be aware of and be prepared to address.
All right, so we have a section here on other bills, and I actually, there's a couple of questions in the Q&A that I would prefer to get to now instead of going through these other bills. They'll be listed in the materials that you receive, these other bills. There's a couple of questions about HELSA that popped up as I was talking about it. And the first question is, does it apply to the common colds, flu, that type of thing? No. So what L&I and the Department of Health will have to do is if there's another COVID-like infectious disease that pops up, which hopefully there isn't, they will designate that this new disease now is covered under HELSA. And that's how you know that you then have to start doing all that notice. Then there's a workers' compensation presumption. And then you have to notify L&I if there's outbreaks, and then the anti-retaliation provisions click in. So it's not everything out there. It's not everything that could be transmissible. It's very specific, highly infectious diseases. The other question that I got is are retail employees covered by HELSA? Yes. Think of it as anybody who regularly interacts with the public as a part of their job responsibilities. So retail, hotels, lodging, restaurant workers, home health care, that type of thing, as well as any employees that are in kind of close proximity to each other where you can't really put any other protections in place, like meat packing, like other industries where there's an expected close proximity. HELSA applies to those and defines them as frontline workers. The other thing I wanted to talk about in our last kind of 2 minutes here is there's an important bill that did not get passed, did not make it out of committee, SB 5891, which has to do with quotas at warehouse facilities and things like that. Those of you who have operations in California might be, unfortunately, aware of AB 701, which basically says if there's a quota as part of a warehousing or distribution or something like that in these very specifically defined areas, then you have to provide information to employees. Washington tried to do the same thing. They essentially copied and pasted AB 701 into SB 5891. It didn't make it out of committee. I know a lot of our clients were very happy that it didn't make it out of committee, but that doesn't mean that Washington won't try again next session. So just keep your ear to the ground. Of course, we'll have more of these presentations over the years as additional bills are passed, and keep your ear to the ground, and that may be something that comes up. There's also a couple other questions that came out on this presentation. They're a little bit more detailed. So, Helen, I don't know if you want to cover them now, or just, I think we're right at the end here, if you want to just follow up with those folks afterwards.
Yeah, I think we can probably just follow up with, I mean, there is one, though, sort of brief about the notice of rights for the Seattle ordinance. And I think the city, and there's a lot to be done, I think, between now and September 1st when it goes into effect, and there will be forms. So I assume that the city will be distributing both their like ideal notice of rights that will, you know, identify, that will be something that you can just pass out in probably in several languages. So that's to be determined, and probably some more rules and guidance that we'll receive between now and then. But we thank you all. We thank you all for joining us today, and hopefully you're going to get some work done with March Madness starting. But appreciate you spending a little bit of time with us. And if you have any questions, we're all here and look forward to hearing from you. Thank you.
Thank you, everybody.